Okay, here's part 2 of the judicial branch. This time we're going to focus on the Supreme Court and what they do, how they're structured, and how a case goes through the court. Okay, so in the Supreme Court, generally they have appellate jurisdiction for almost all of their cases. In really very few cases, they have original jurisdiction. In certain cases where a state is a party, and then cases involving representatives of foreign governments. So if an ambassador from another country in Washington, D.C. decides my rights are being taken away, although they don't have many rights under the Constitution, that case can be heard in the Supreme Court. But the problem with that is, the trial can be heard in the Supreme Court. That's what gives them original jurisdiction. The problem is, if you lose your trial, where do you appeal from there? There's no other place to go. So probably be smarter to start that case in the lower court. Okay, they set precedents that lower courts must follow. Stare decisis is one of your terms, okay? So the cases that they take are the really important cases. You know, there are 4,000 or 5,000 cases appealed to the Supreme Court each year. They take about 100. So they take and out of those 100 they take, in the news, we probably hear about 4 or 5 of those a year. So they take the really most important cases, and the most important of the most important are the ones that we hear about in the news. But the reason they take those cases is they want to set precedents, a structure for other courts to follow. For instance, when the court issued Brown versus the Board of Education in 1954, one of the things that they did was they said, this is a precedent. All segregation in education is unconstitutional. They made that statement. So any other case that came up from then on that dealt with educational discrimination, educational segregation, that segregation was automatically determined to be unconstitutional because of Brown versus the Board of Education and the precedent, the framework that the court set. Okay, now how does a case get to the Supreme Court? Well, like we talked about last week, the cases go through a lot of other courts. A trial court, an appeals court, might be the state Supreme Court. Okay? Well, then once it's appealed to the Supreme Court, if they grant certiorari, that means that they put their case on the docket. They issue a writ of certiorari. That means that they get all of the proceedings, files, documents, evidence from the previous court. Now, that's probably going to be from a state Supreme Court or a federal court of appeals. That means they're going to take the case. They don't want the records if they're not going to hear the case. So once they get the records, it's pretty clear they're going to hear the case, and then they put it on the docket, the calendar for the next year. So the Supreme Court begins on their term begins on the first Monday in October, and it runs usually through end of June, beginning of July. They're usually finished by July 4th. Okay, so the cases that they're granting certiorari for now, unless it's there's a time constraint, they're going to hear those next year, either at the end of this term or the beginning of the next term. Okay, then they accept briefs from both sides of the case. A brief is a legal summary. Sometimes they ask for amicus curiae briefs. There's another term. Amicus curiae is a friend of the court brief. So these are opinions of parties that are not directly involved in the case. In other words, they're not the defendant or the plaintiff in these cases, but they want their opinion to be heard by the court. So that's amicus curiae, friend of the court brief. It's the way to lobby the Supreme Court. It's a way to get your opinion in. For instance, if there's this free speech case currently on being heard by the court, that American Civil Liberties Union might decide to file an amicus curiae brief. The American Civil Liberties Union focuses on, one of the things they focus on is free speech. They might say that it's very important that the Supreme Court, issues an opinion that is in favor of free speech in this case. So they try to influence the court, the judges on the court. Okay. And then the next step is they have oral arguments. Okay. In oral arguments, you actually go into the court, and you go before the judges. You have about 30 minutes, sometimes 45 minutes, sometimes an hour. They usually set the time limit for them. And if you're there, you're the lawyer. You're not actually the person. You're the lawyer for that person. And when the green light goes on your podium, you start saying to the justices, here's why you should decide in my client's favor. Now, during oral arguments, a lot of times they're interrupted by the judges, and the judges will ask questions. And court watchers always kind of look at and read between the lines on the judges' questions to try to figure out, how are they going to decide on this case? If the United States government is a plaintiff or a defendant in the case, then Noel Francisco, he no longer is. He's had this job through March of last year. He was the Solicitor General of the United States, so he would be the one that would do the oral arguments. And then the judges conference, and then they issue a decision, and they read an opinion. And these opinions on why they decide a case usually is 15, 20, 30 pages. That's the winning side issues the majority opinion. Sometimes the losing side, the 4 judges or less on the losing side, decide we're going to write our own opinion. That's called a dissenting opinion. Here's why we disagree with the ruling in this case. Okay, these 5 steps don't happen overnight. It usually takes the court system runs a little slow. So when they grant certiorari and accept the briefs, that usually happens. That happens pretty quickly, but the oral arguments happen, months later. Then they confer, and that might be 3 or 4 weeks after oral arguments, and then their decisions are issued maybe a month or 2 after that. So it takes a good 6 months or so before somebody is granted certiorari and their case is actually decided by the Supreme Court. Now, the Supreme Court, there's checks on their power. We talked about these last week. Okay, so their power is not unchecked. Congress they determine the size and the scope of the federal court system. So they make the rules for the federal court system. And if they don't like, that there's 9 judges on the court, that's not a fixed number. They can change that. They change that to 12 or 11 or whatever. They can break up a district court in, one district into 2 districts if they want to. So they make the rules for the federal court system. They can add an amendment to overturn a Supreme Court decision. That's been done a few times. The 14th Amendment, which granted citizenship to freed slaves, that was an overturning of the Dred Scott decision. Okay, the president appoints all federal judges, and the Senate approves them. That's another check on the court's power. So, and then there's no enforcement power. We talked about this last week. There's no federal Supreme Court army, so how do they implement their decisions? They can be ignored. Usually not, because most people have respect for the court, and they respect what the court decides. Okay? Now, when nominating a judge, what is considered by a president? Okay, first of all, there are no qualifications required to be a federal judge or a Supreme Court judge. Now, normally they pick somebody with experience in the law. They're a legislator. They're a lawyer. They've worked in the Justice Department of the United States government, that kind of stuff. But you want somebody to be highly qualified. You don't want to. No offense to plumbers out there, you don't want your plumber, the White House plumber, to be nominated for Supreme Court judge, because they won't be confirmed by the Senate. So you got to have somebody that's confirmed by the Senate. And the president almost always appoints ideological allies. I have why. The answer is because they serve for life. The longest serving judge on the Supreme Court was appointed by George H.W. Bush. George H.W. Bush stopped being president in 1993, and he died 2 or 3 years ago. So put somebody on the court, especially somebody young, that's your ideological ally. When somebody's done being president, they can have an influence on the judicial branch. That president can have an influence on the judicial branch years, decades after they're finished being president. And we'll talk about Trump's appointments and the kind of appointments that he made and how he's had a really big influence, even though he's a one-term president, has a big influence over the judicial branch for the next couple of decades. Okay, ideology is the key. Judicial activism. Okay, the Constitution changes with the time. Somebody that has a judicial activist viewpoint believes that the Constitution changes with the times. The judges change the meaning of the Constitution. Okay, it's not 1789, it's 2021. The Constitution needs to work for us. Therefore, judges can interpret the Constitution to mean things over time. And you can look at the 14th Amendment as a great example of this. Many, many more groups have been included under the 14th Amendment as groups that were defined as being treated unequal, and now the law says that they have to be treated equally. The LGBTQ community is currently being placed under the 14th Amendment as being protected and having legal protections under the 14th Amendment. That didn't happen 100 years ago, even though that amendment was there. The makeup of the court changed, and there was more judicial activists on the court. Okay? A Democratic president is more than likely going to choose somebody who is a judicial activist, although sometimes Republican presidents have. Sorry, let me say that again. A Democratic president will more than likely choose a judicial activist, although sometimes Republicans, not knowing, choose a judicial activist. They think they're appointing a judicial restraint person, and vice versa. Democrats sometimes can appoint somebody who they think is going to be an activist, but in reality is judicial restraint. Judicial restraint people are conservative judges, not conservative politicians, but conservative judges, and they're normally appointed by conservative presidents, Republican presidents. Judicial restraint people believe that you take the Constitution at its word. You don't add meaning to the Constitution. The Constitution means what it says. If you want to change the meaning of the Constitution, it's not a judge's job to do that. It's the people and the Congress and the states by adding an amendment to the Constitution. Okay? And by the way, these are not absolutely 100% across the board, and you probably know this based on politicians. Politicians can say they're conservative, but they might vote for a liberal law, and there might be a liberal that's said I'm a dyed-in-the-wool liberal, but they vote for conservative laws. Judges are no different. Okay, a lot of times they, and this has been a more recent thing, they appoint lower court judges to be on the Supreme Court of the United States. Okay, I'm sorry. So that's a modern thing. So now. If it's a lower court judge, a court of appeals judge, or a district court judge, the presidents use senatorial courtesy. So they'll ask a senator from that state. So if it's a district court in Ohio, a federal district court in Ohio, they might say, okay, now senators from Ohio, can you give me a list of 5 names of people that you think should be judges in the lower courts, in the federal lower courts, and they give a list of names, and the president chooses from that. They submit names back to the senators, and the senators say, I'm sorry, I had that backwards. They have names, and they have a list of names, and they give them to the senators, back to the senators, and they say to them, what do you think? And the senators give their thumbs up or thumbs down, although it's up to the president to decide who's going to be that judge. Now, things have become politicized. Especially when appointing a Supreme Court judge. The president, that's a big decision the president makes. And the president doesn't ask senators, who do you think I should put on the Supreme Court? They make that decision basically themselves. But once anybody is appointed to a federal judgeship, they have a hearing before the Judiciary Committee, usually before the Judiciary Committee of the Senate, because only the Senate, the House of Representatives, is not involved in this. Okay, so the Senate says, the Judiciary Committee, we either give a thumbs up or a thumbs down on this nominee. And if they pass that litmus test, then it's sent to the entire Senate, and the Senate then votes on whether or not that person should be either a Supreme Court or a lower court judge. Okay, sometimes this doesn't work as well as the president planned. In 1987, Ronald Reagan was president. He appointed a guy named Robert Bork to be on the United States Supreme Court. Bork did not make it out of, actually he made it out of the committee, but he was voted down by the entire Senate because he was too conservative. And the Senate at that time the majority party was Democrats, so they didn't want that person, Robert Bork, to be the judge. So they voted him down. So then Reagan says, all right, now I got to get another person in there. And he appointed this guy last name was Douglas. I don't remember what his first name was, but he, in his committee hearing, admitted, now this was 1987, that while he was in college, he was a pot smoker. And the committee chair goes over to the president and says, you got to withdraw his name. We're not going to, he's a pot smoker. He's a pothead. We're not going to go ahead and send him to the Senate. So he then appointed Justice Kennedy, who recently retired from the court, and he passed with flying colors. So sometimes it depends on who's in charge of the Senate. You know, if the president's party is in charge of the Senate, numerical majority in the Senate, they're probably going to appoint a more ideological judge. But if it's a Democratic president and a Republican Senate, they're going to their ideological judge probably might not make it through. That's what happened with Robert Bork. So they're going to appoint a more moderate judge, somebody that sometimes believes in activism and sometimes believes in restraint, and those usually make it through. Now, who are the judges on the Supreme Court? Who are these 9 judges? And I'm going to go in order of how long they've been on the court. The guy that's been there the longest is a guy named Clarence Thomas. He's a conservative. He was appointed by George H.W. Bush. He has been on the court since 1991. So that is 29 years. And he appointed, Bush was smart, even though he's passed away since then, he appointed somebody who was young. Thomas is he was in his 40s, so he's now in his 70s, early 70s. So he may be on the court for another 10 years, 15 years. Stephen Breyer was appointed by President Clinton. He's a liberal judge. He believes in judicial activism. Okay, when George W. Bush, I want you to keep track of these next 2 presidents because they were both 2-term presidents. Okay, they both got to appoint 2 judges in their 2 terms. Okay, the guy first person that Bush appointed is John Roberts. He's now the Chief Justice of the United States. He is judicial restraint. He's a conservative, but he is actually moving towards the center. He's more of sometimes restraint, sometimes an activist judge. Samuel Alito is he's a straight up conservative. He's like Clarence Thomas. He's a straight up conservative. Really doesn't go beyond usually sticks with their viewpoint. Breyer's the same way. He sticks with his activist viewpoint. Okay, now Obama got to appoint the first Hispanic American, Sonia Sotomayor, onto the court, and Elena Kagan on the court as well. He appointed 2 women to the court. So in their 2 terms, Bush and Obama, they were president for 8 years, they got to appoint 2 judges. Now, Trump, when he was president, he was a one-termer. He's been able to appoint 3 judges. That's very unusual. And he appointed conservative judges. Neil Gorsuch is somebody who is mostly conservative, but sometimes he can be a centrist judge. Brett Kavanaugh kind of leans more towards conservative, and he's sometimes activist. But Amy Coney Barrett is the newest judge. She's only been on the court for a couple of months. She is very, very conservative. Although, well, on paper she is, but she hasn't issued many opinions and been involved in many decisions yet. So the jury's kind of out on her on that. But Trump appointed fairly conservative judges to the court. So if you count the C's and the L's, it's 6-3. There's 6 conservatives and 3 liberals on the court. So there's a definite conservative majority on the court. Okay. You may have heard this cliche before, elections have consequences. They do, okay, because there's been, in this century, there's been more conservative presidents than liberal presidents. There's more conservatives on the Supreme Court. Okay, now, last thing, you have an assignment on looking at one of the oral arguments of the Supreme Court, okay? It's the Masterpiece Cake Shop case. This was a very, very famous case, one of the most famous cases in the last few years in the Supreme Court. I want to give you the background, and then I'm going to have you listen to the oral argument on your own and give me your opinion about what was going on in the oral argument. Okay, the case starts when these two guys here get engaged, and I'm emphasizing two guys because that's a big part of the case. They decided to get married in Colorado, where same-sex marriage was legal in Colorado. These guys must have money because they went to the owner of the Masterpiece Cake Shop in Boulder, Colorado, and asked them, can you make a cake for our wedding? And he said, sure. He is a master cake, I mean, it's in the name, Masterpiece Cake Shop. So this guy doesn't do, traditional wedding cakes. He makes basically works of art. And when they came to him, he didn't approve of their marriage. He is the owner of the Masterpiece Cake Shop is a religious conservative. He doesn't agree with same-sex marriage, but he didn't let that get in the way at first. So he's like, well, what do you want? What do you want your cake to look like? And these two guys had some ideas. And the more ideas they brought to him, Masterpiece Cake Shop guy got a little nervous about this because he thought, oh, man, I don't agree with what they stand for, but I'll still give them a cake. And then things came to a screeching halt when they said, oh, by the way, on our cake, we would like these messages. And they were pro same-sex marriage. From what I understand, pro same-sex marriage quotes that they wanted on their cake. And the Masterpiece Cake Shop said, I can't do that. The owner said, I can't do that. You're making me express a viewpoint because at the wedding, the cake will be there, and they always have a sign that says, this cake was bought at Masterpiece Cake Shop. He's like, I don't want to be associated with those ideas. And these guys said, well, the 14th Amendment of the United States says you can't treat us differently under the law. And he said, yeah, but the First Amendment says I have a right to freedom of religion and freedom of expression, and you're making me express things that go against the practice of my religion. So they left the cake shop and got a lawyer and then sued. Okay, and that's basically the background of the case. So at this point, I want you to look at, listen to the oral argument. There's a link in this week's homework sections, and tell me what you think.